I will call this meeting to order. We are missing one member, Katie.
I don't know.
Okay.
I can't imagine she won't.
Well, we have a quorum, so we may move ahead. This is a properly advertised meeting. All who wish to be heard will be heard. We have two applications before us tonight. Is Mr. Sacker here? Or his representative? Okay, Mr. Sacker? Mr. Sacker? Yes, come up, please. Mr. Sacker is one of the people proposing the new Paltz Water Street Cinema. It is my understanding that there has been some conversation with Mr. Sacker.
Yes.
This is our planner, Kurt LaValla. You have a presentation to make to us.
Well, actually, the only update is, of course,
Oh, wait a minute, we really need to open the hearing. So sorry. Motion to open the hearing?
So moved.
All in favor?
Aye.
The hearing is open, and we can receive information now.
Yes, I mean, just conveying the essence of my conversation with Mr. Sagar, is that I think he wishes to ask the board to extend the time period in which a decision would be due on this application.
All right. And the purpose of that?
We are reconsidering our proposition.
Okay, okay. Is there a specific amount of time you wish to have for that?
My understanding is what we can do is, you have 62 days and we can do it for another 62 days. That would bring us into
All right.
Yeah, March 13th. I'm sorry, it would bring you to your March meeting, March 2013 meeting.
Okay. So what you're asking is that we table an action until March the 16th.
Yes, let me just confirm the date in March. The second Tuesday is the 12th.
Is that more than 62 days?
I don't believe so. I tried to do a straight count in the office today.
Starting from today.
Right, or actually, well, the hearing, as I contacted you today and left a message, the hearing had been closed by the Zoning Board of Appeals at the last meeting. So I counted from then. The first 62-day period brings us to our meeting in January of 2013, and that's January 8th. And then 62 days additional, with February having only 28 days, allows us to, or brings us to our regular meeting on March 12th.
Okay. I will entertain a motion to the effect that the application of Mr. Sacker be tabled until March 12th,
Yes.
a regular meeting of the ZBA. Do I hear such a motion?
So moved.
Is there a second?
Yeah.
Is there any discussion? All those in favor say aye.
Aye.
Opposed, like sign? Unanimous? Okay. You have your time, Mr. Sacker.
Thanks very
Chairman. Don Nickel, I'm representing the Neighborhood Association.
Yes.
We don't mind an adjournment, obviously, it's his application, other than if there's any substantial changes, we want an opportunity to review those and to then comment
Yes.
on those. So, will he be making a presentation in between, or is that the date he'll be bringing his
That's a good point.
new presentation?
My understanding is, and again, you're right, we're not able to ask him, but my understanding is that this item would not be on the agenda again until the regular meeting of the ZBA on March 12th. Tuesday, March 12th. I think it would need, and as much as it required mutual consent to adjourn it until then, I think it would require mutual consent to come back, say in February, if the applicant wanted to. That would also require mutual consent of the board and the applicant.
Yeah, well, as long as we have an opportunity to see what the changes
Of
are
course.
and be able to comment on the changes.
If we modified what we have just done to February 12th, which would be our regular meeting in February,
Well, we don't know what and when he's gonna present. He didn't tell you that unless he told the planner and the.
No, actually, it was only,
You know, our concern is just that.
Back there.
Oh, is it?
please, if you have something that you need to say, please address the chair. You recognize the chair. Thank you.
You know, we would just wanna be notified when a submission comes in and then have an adequate time to look at it before having to try to comment on it.
All right.
And,
Would this,
and we, you know,
would this be satisfactory? That we would ask that at least a week before the meeting in March, that you be notified as the person representing the folks who are involved and concerned with this, and given an opportunity to see whatever kinds of modifications and plans have been made.
well, a week is a fairly minimal time. We certainly, you
How
know,
much time would you like, sir?
well, I think 2 weeks would be appropriate.
All right.
You know, have an opportunity to look at it and comment, and perhaps do some research.
Okay. Is that agreeable to the members of the board?
Yes.
Okay. Let the minutes show that there will be a 2-week period before the meeting of March the 12th, so that the folks who are interested will be able to see whatever the changes may be in that proposal.
Chairman Budman, I just asked that his contact information.
Would you speak more loudly,
Chairman
please?
Budman, I just asked that his contact information be given to the clerk's office ahead of time so that we can properly verify.
I will be happy to give a copy now, and I gave a copy to the reporter, so it can be put into the minutes.
Thank you, David.
May I be clear about something? May I be clear about something? I just want to fully understand that I understand what I understand.
Okay.
Okay.
Fine.
So, we will meet in March to make a decision about what's then before us.
We probably will not make a decision when we meet in March. We may indeed want to keep that
Review.
matter open so that the public may have an opportunity, and we may have an opportunity to suggest whatever the public says to us.
Okay, but having the materials, the point is that the date is in March, but we will all have the materials 2 weeks before.
Yes.
Okay.
Yes.
I don't want them as much as
Mr. Chairman, I would like to see the public hearing reopened prior to that meeting, or at the time of that March meeting. It was closed last time.
I'm not sure what you asked, sir.
Well, I think he asked if the hearing would be open. I think that would be appropriate when there's a change, that the
Sure,
hearing officially is open, so
When,
there's no doubt that, you know, we're
when we
commenting
see
for the
a
record.
new proposal, it's a new application, and we begin with an open hearing.
Good. Set?
Now, I know a number of you have come here tonight because you are interested in what the original proposal was. Now you know that there is going to be some revision by the proposer, and none of us know what it is yet, but you will know before the meeting. If you wish to stay, we will be dealing with another application, and you are more than welcome. If you wish to go, we'll give you a few minutes to go.
Was it clear that they're revising the proposal, or they're considering whether or not to go through with the project?
Yeah,
That was not clear.
No.
we don't have any information, other than what was said. The village does not have any additional information.
Did somebody take notes about what was just said? I just wanted to hear that language.
I don't know if anyone recorded it, no.
Can we ask him directly?
I believe it was to reconsider the proposal.
He said they were, I believe he said they were reconsidering what they were proposing.
That's
And I
right.
took it that they would tell us what their reconsideration was.
Do you have that in
That's
minutes?
what my minutes reflect. I will be looking at this video recording and taking the exact language down. I
Good.
can't say what his intentions are as to his
Could Mr.
application.
Suture clarify it? He's right here.
I'm having some difficulty
Or
hearing.
did
Say
say
it
his
again.
name?
Yeah,
Could
Sacker.
Mr. Sacker?
Yes.
No, he's right here. Could he clarify what he said? I mean, just repeat what he said for the record.
That's up to him.
It's up to me, it was recorded, you have a recording of it. I'm not sure what you asked.
I was asking that you repeat your reason for asking for an extension.
It's been recorded forever on film and by electronic equipment. I don't think there's a reason to repeat anything he said.
We're trying to decide if,
At this point, we-
Nothing's gonna happen tonight on
this.
At this point, we don't know what revisions will be made, but we do know that whatever revisions are made will be available to you in advance of our meeting. All right, let us move on then to the other application.
Well, give us a few moments.
Yeah.
Appreciate it.
Alan, did you get a copy of this?
No. Oh, that's not the only way. Is that what that is? I did not get that. I tried to read it.
John Ryan is not with us tonight? No. No, we decided he didn't need to.
Okay, so, okay, as long as you know how you want to handle this next matter.
Okay.
And Katie's not here. Katie's not here.
Katie isn't taking minutes, though.
No, Katie.
Oh, no, I don't see her, so I assume she's not.
Okay, so this is.
My little girl
this
got
is
sick,
something that I
so I can go to where I'm supposed to, and
Well,
she's
I-
sleeping now, with that, she's really bad.
I will ask Katie if she will
Watching
get a copy.
in our offices to
Did
do.
you get a copy of this? All right. Obviously,
No, it was on the internet.
Yes, I read it, sure.
You read it online? I found it very difficult to read online.
Oh, no, I didn't read it online, I get it.
I read it online.
Because my computer's in printable in States.
Neither is mine. I need.
Oh, she asked Katie.
I read it on.
Have missed it.
I mean, let's put it this way, I
That 2 12
read it
hour
online.
college is not really well. Then she had the class, I said to my husband, "You stay
I guess we, all who have gone, who wanted to go ashore have gone ashore. All right. Well, Dr. Nash and Christine Marlowe here, would you come up to the table, please? This application is a request presenting an appeal to a decision by the building inspector regarding the expiration of the SUP at 127 Main Street. Now, this is a new application. As such, none of the materials that were submitted to this board are a part of the record for this application. If you wish those materials to be included in your application, we need to know that that's what you want done.
We do.
Okay. Let the minutes read that all of the materials previously submitted with regard to the question of the expiration of the SUP at 127 Main have been entered into the record of this application at the request of the applicants. Thank you. I would ask that the board open the public hearing.
So moved.
Second.
Favor? Everybody in favor?
Yes.
Aye. Okay. All right, now we are at a point where if you have new material to enter, we already need yours.
Okay, many people were here tonight to speak about the request for a parking variance for the Water Street Cinema. The room had been similarly packed on many occasions for public hearings concerning 127 Main Street. But the public never had any input for a variance that would grant permission for a bar to open so close to a residential district, a church, and a school, all prohibited by village code. There was no public hearing because the owner never applied for a variance. An SUP was granted in violation of village code. The many neighboring residents on Prospect Streets and Orchard Heights have had to live with a raucous drinking crowd disturbing our sleep late into the night. That is, whenever the business was open. As everyone in the village knows, the various bars at 127 come and go, with no business operating for long periods of time. After the first closure for more than 6 months, the SUP was not deemed to be expired, as the building inspector, Ms. Moniz, said that the business was open one day, the day she conducted her fire inspection. Residents were stunned at this claim, as the windows had been soaked for months, including the date of the fire inspection. So this time, with no business operating for about a year, the neighbors made sure to provide documentation clearly indicating the authorized special uses had ceased for over 6 months. In our appeal, we will present this documentation and have presented much of it. But at this time, we would like to request that our appeal and interpretation be postponed. To ensure that we complied with village code, we filed our appeal within 30 days of the building inspector's September 11, 2012 determination that the authorized special use had not ceased for a 6-month period. However, on June 18, 2012, the building inspector had made the opposite determination, that the SUP had ceased for over 6 months, so that the SUP had expired. At this point, the owner of 127 has filed a lawsuit with the village concerning the first determination, the expiration of the SUP. To prepare for our appeal, we attempted to find out if there is a final determination. We received the following message from Joe Ariel, the village lawyer. Christine will.
He responded to me, and for the record, from Mr. Ariel. Ms. Marmo, as you know, this matter is in litigation. I've advised the village that there should be no comment on such inquiries while the litigation is pending, as your question calls for a legal conclusion, which must await the determination of a court or the resolution of the matter by stipulation. In the meantime, the record must speak for itself. We're not sure what the record is, so we would like to postpone our appeal and interpretation until this lawsuit is settled.
Need a motion? So moved.
You're moving that.
I'm moving that,
The decision or the resummation of this await the settlement of the lawsuit.
That's correct.
All right.
I have one other thing to
Yes.
say before. It may seem odd to everyone that Dr. Nash and I are continuing with this appeal, and our neighbors, given that Chez O'Brien's, in its current incarnation, by all accounts, is quite a pleasant restaurant.
Mhm.
To date, the establishment has been a model neighbor with no noise, no amplified music, no disturbances. If Chez O'Brien's and Mr. Murtaugh expect to continue Chez O'Brien's in its current state and not plan to convert the restaurant into a raucous late-night drinking establishment after 10, which was the case with the other places, Mahoney's and Rascals, then why is there so much money, lawyers, and time spent trying to keep this current SUP? new SUP would be easy, inexpensive, and available. We neighbors need to safeguard against another Mahoney's or Rascals. And it must be noted that the current owner of Shea O'Brien's, Mr. Murtaugh, co-held the liquor license for both Rascals and Mahoney's. In effect, there's really no new business. Once all of the lawsuits have been settled with Shea O'Brien, will Shea O'Brien's become another neighborhood catastrophe? So we continue our appeal to prevent that, and if it continues as it is, we would be ever so delighted.
Do we have copies of that?
Of what I said?
Yeah.
I don't know if this is, yes.
Wait a minute, we've got a motion on the floor.
Yes?
Wait, Carl, we got a motion on the floor. I made a motion.
Oh, I'm sorry.
Need a second.
Is there a second to David's motion, which is to allow them time to resume their application once the lawsuit is settled? Who seconded? All in favor?
Aye.
So moved. Yes, sir.
Good evening, thank you for listening to me.
Would you stand, please?
My name is Kevin Murtaugh. I'm one of the owners of Shea O'Brien's. I just wanted to say that, ladies, thank you that you think that we're model neighbors. That means a lot to me, but I was never partners with the people that were in Rascals. I was never partners with Dino or Gina or anybody else in New Paltz. This is my first trip to New Paltz.
You were on the liquor license.
I bought Rascals. I just state for the record, I bought Rascals, the company, and they transferred the liquor license. And my name became on the liquor license as of September 6th. That liquor license expired September 30th. So I just renewed the liquor license. I bought Rascals. I didn't apply for a new liquor license. I bought Rascals Corporation. I have never had any business in New Paltz until just now. You can search with the New York State Liquor Authority. I have a New York State liquor license in Rockland County. I run a respectable business in Rockland County. I run a respectable business in New Paltz. I try so that families can come in, have a nice meal, enjoy themselves, maybe a laugh, maybe unwind after a long week. We're a restaurant that sells alcohol. So people want to have a couple of drinks after dinner and whatnot and enjoy themselves and tell a joke and laugh with their neighbors. I don't see what the problem is. You know, I never seen so many issues. And as for why all these attorneys and all of that are there, they're not on my behalf.
No.
They're not on my behalf at all. They're on the landlady's behalf. Has nothing to do with me. But I'm here just to say that I run a respectable business, and I have another business in Rockland County since 2001 with an unblemished liquor license. Nobody can say anything bad about me. And I come up here and I read articles in the paper that I'm this kind of, I'm a monster. I'm running a gin mill, and I'm not. I'm running a nice restaurant. I'm friendly to everybody, and the people in New Paltz have been extremely friendly to me. Extremely friendly. The people in this office, the police department, the fire department, all my neighbors have been spectacular to me. But you have to, we're nervous because we spent a lot of money in that place. We made that building extremely nice. And for somebody to say that your special use permit and it's swiped out from under you, now we're sitting down on the sidewalk high and dry. That's not right. You know, I entered into a lease with an option to buy the building in good faith. And the special use permit was in effect. Me as the tenant, I did nothing to destroy that, to bend that. I didn't bend any rules. My restaurant is open. We're a bar restaurant, we're a restaurant bar, we're whatever you want us to be, you know. We're a restaurant that sells a lot of food and good food, and as a course of that, we sell alcohol and beer and wine. Nice alcohol and nice wine. We don't have the hypnotic girls, and we don't have bikini contests and things like that. But at the end of the day, it's an adult place. There's a reason why I have a liquor license. There's a reason why it's okay for me to have a liquor license. We're not in the business of selling ice cream. Things happen when people drink, and we do our very best to police our own. I think I did a hell of a job in Pearl River for 11 years, and you can ask anybody. My reputation stands for itself in the place that I have in Pearl River, and I intend to do the exact same thing up here. I went and talked to the police department before we opened. I went and talked to the fire department. I don't want any problems. If there are any problems, even if there's any problems with my neighbors, if there's a sound problem, a noise problem, a dance problem, a light problem, come and talk to me. I'm a regular jamoke, you know, just come and ask me, like, listen, it was a little bit loud, that window, that light you have in your back window is shining right in my kitchen, can you move? I move it, it doesn't matter to me. I want to get along with my neighbors. I want my neighbors to come in and be part of my business. I want to be ensconced in the community in Newport. There's nothing but nice people here. I just, don't prejudge me on what was there before me, because I can't do anything about Rascals or Mahoney's West or God only knows Toscani's Deli. I don't know. All I know is what I bring to the town and what I bring. I employ 34 people from Newport's now. You know, 34 people in Newport's have a job because of me and my partner. So, you know, the sales tax is going to go up for Newport's because of me and my partner. Property tax is now going to be paid because of me and my partner. So, I don't see what, like, we're not these big evil ogres, you know? And I know you're looking through there for the liquor license. I wouldn't lie to you because, like, it stands for itself. I'm the owner of a liquor license in Newport since September 6th of this year. Never before. My hand to God, you can call the liquor authority.
No, I got a copy of it before.
Please do, please,
Yeah.
because you got bad work, you got bad paperwork, because
No, it was from the SLA.
from the SLA, I applied in April for a change of ownership.
Sorry.
I applied in April for a change of ownership, and that got approved on September 6th or September 7th. And that change of ownership, that liquor license expired on September 30th. So when your liquor license expires, just like in any other bar, just like your New York State driver's license, you have to renew your license. We renewed our license. I only had the damn thing for 29 days. I wasn't happy about spending another $4,000 to renew it. I did what I had to do, and we just renewed my license. My license has been in Newport since September 6th to September 7th of this year. I'm not trying to pull the wool over anybody's eyes. I'm not trying to make it a topless bar. I'm not trying to make it a biker bar. I'm trying to make it a nice family place where people can come, enjoy a bit of music, enjoy a bit of laugh, and enjoy a nice meal, bring their children if they want to. That's what I want to do, you know? And that's really all I have to say. But it seems I was at the meeting in the summer, and they painted me out to be this big ogre. As you can see, I'm not. I like to think of myself as a really nice guy, you know? I'm a family man. I don't wish harm. I'm not trying to do anything to anybody in Newport. I just want to be friends with everybody. I love the community up here, you know, and I want to be part of it. That's all I have to say. Thank you.
Well, thank you.
May I talk to Mr. Murtaugh, or is that?
No, if you would.
I think your place looks great. When you did enter into this, you must have seen that there was a stipulation for no amplified music.
Yeah.
So that would be a stumbling block for you, I'm sure.
My problem is with amplified music, and my attorneys and the attorneys for the landlord, nobody could seem to know what amplified music was. And in my eyes, when I turn the radio on, that's amplified music. When I pick up the phone and can't hear the person on the other side and turn the volume up on my phone, that's amplified. When the guy in the gas station next door to me turns on his radio, that's amplified music.
Mm-hmm.
If you give me but if you give me a decibel level that you want it below, it's not a problem. I'm not trying to hurt anybody.
No.
The building is soundproof. I turn, you know, you can.
This went in front of the ZBA
Yeah.
in an incarnate with Mahoney's West.
Yeah.
And they argued the same. They argued that if it's through the house sound system, it's not amplified. Well, I mean, that's absurd because you don't need a PhD in acoustics to know that you can hear through a house sound system.
Okay.
The idea was that neighbors would not be affected by bands or DJs.
Correct.
So that says in the SUP, no amplified music. So if that is something that needs to be, if you're questioning that as a business owner and putting in, you know, lots of money, I would think that that would be something you would want to really be quite sure of before you went further. In terms of bands, now you could have an Irish acoustic band, that's not amplified.
Right.
But a DJ, any kind of amplification through speakers, that's amplified.
Yeah. But see, what I don't understand is like when you say I could bring an Irish band in there, and I'm not trying to be a wise guy. I could bring 10 bagpipers in there to blast out.
I know.
But I wouldn't, like, out of respect for the neighborhood, I don't wanna do that. I just, you know, a bit of music or put the Giant game on so that people can watch the Giant game and like, because I'm sure there's, I don't know, I sell food and drink. I'm not a DJ, I'm not a music guy, I don't know electricity. I know if I turn the Giant game on and somebody says, you know, there's an old guy in the back and you turn it up a little bit, I turn it up a little bit first so I can watch the game. If I got a guy playing DDD music and he's got a microphone there, you know, I'm not trying to blast you. I'm not trying to blast you out of the neighborhood. I can honestly say in my heart of hearts, you've never heard any sound bellowing out from my business.
All right, I'm going to interrupt this at this point. I see someone else wishes to speak.
So my name is Michael Zeeler. I'm a member of the Village Planning Board. I'm not speaking in that capacity. I'm just speaking as somebody who's lived here for a long time and seen a lot of local land use disputes. May I suggest, given some of the comments that I've heard and having met the new owner for the first time tonight, that perhaps it would be of value to try to resolve this, or at least give the owner an opportunity to develop his reputation in New Paltz by starting afresh. So if indeed, as the people who spoke here tonight are suggesting that they are remaining vigilant because the current disputed SUP is still in effect, that perhaps it would be worthwhile for individuals, neighbors, and the applicant in particular, the property owner or the business owner in particular, to consider submitting an application for a new SUP that would go before the village planning board. And new conditions could be worked out during the terms of that. The old SUP could be by mutual agreement annulled. I don't know at the moment, since this has just come up, whether or not the property owner would agree to this and what role they would play in that. But that might then provide a new foundation in which the neighbors might feel more comfortable. The owner would feel like he's starting, the business owner would feel like he's starting with an opportunity to develop their reputation here, because clearly, as we've seen at recent planning board meetings, people who want to open new businesses here or move existing businesses, we had 2 recent applicants, people who appreciate their reputation will come out in droves to support them, as happened recently. And so, if indeed things are looking okay, perhaps this is a way to give this gentleman a chance to do something.
Thank you for that reasonable proposal. It may be, Mr. Mercer, that you want to talk with the owner of the building regarding the possibility of your applying for a special use permit of your own.
Sure.
I do want to say to you that all of the feedback which I have heard regarding your establishment has been very positive. People have enjoyed the atmosphere, they rave about the food. I think it should be clear that you are living up to whatever is allowed presently on the special use permit that the owner has. And I say that because when that special use permit was issued, it was issued with the expression restaurant/bar. That was not the intention of the planning board to have 2 separate functions. The intention of the planning board was that this was a restaurant with an auxiliary bar, which would be sensible and legal with respect to accompanying the serving of food, and hence would not be a violation of the local code, which says if it is a bar, it cannot exist within 200 feet of a residence, 400 feet of a school or a church. So it essentially is not either illegal or inappropriate. Moreover, I have been informed that the size of the bar that previously existed has been appreciably reduced, so that in essence, whatever the good things that you folks have been hearing about Shea O'Brien's at this point have been verified. And we can all hope that this continues and that your business is very successful. It is, I think, understandable that people who have in the past been burned
Sure.
were at least initially suspicious. And I think that their suspicions have been largely allayed.
I hope so. I hope so.
Yes.
My name is Jane Daly, and I do represent the landowner here, so.
Yes.
We have had discussions about Shea O'Brien's going in for a new special use permit.
Mm-hmm.
And the idea was that they would give themselves 6 months to establish a reputation in the community, so that when they went before the planning board, they had their own track record behind them. The other thing that's up in the air right now is the parking requirements.
Pardon?
Is the parking requirements. There's the parking study, and I know there's lots of conversations about what the parking requirements were. So we didn't want to go in for a new special use permit until such time as some of those issues were taken care of.
Don't you have parking behind that building?
We do, but there were lots of questions raised, and I heard Michael chuckle, about whether or not the parking is adequate, whether or not there should have been drainage. Honestly, going before the planning board at this point would reopen all those questions, and I'm not sure that that's something that the applicants are ready to deal with now, which is all the reason why they're spending the money on the lawyers to protect the rights for Shea O'Brien to be open in the meantime.
Mm-hmm.
And with all of that, I just want to say I don't object to an extension of the time for them to prepare their appeal, but the determination by the village board is wholly and distinct from any determination by the building inspector on this. And it appears that they disagree. On the June 15th minutes of the village board, they determined that the special use permit had expired. They gave no rationale for it. We never had an opportunity to present any defense to their determination. That's what the Supreme Court case is about. That could take a year to a year and a half to get a determination, because it's a two-part case. One is what's called an Article 78, which is the appeal of that determination, and the other one is an associated suit, which is called a 1983 action, and I give you the jargon because it might reference something for you. The 1983 action is a personal action against the members of the boards individually, because they didn't afford the applicant an opportunity to come before them, but they afforded the neighbors an opportunity to come before them, but they didn't contact us. Not here to determine whether or not that's appropriate, that's what's before the court. Those actions can take a lot of time. I can tell you that currently, the village is not being represented by Joe Ariel. They're being represented by their insurance company, because the village is insured against 1983 actions. So this is not a simple thing that's going to get decided in the next several months. It's going to go on for a while, because there are all sorts of discovery and testimony that will be taken. So it could be a long, protracted thing. My concern is that we've left Shea O'Brien's hanging out there until this determination, which is separate and apart from what the building inspector has said, for potentially a year to a year and a half, which I don't think is fair to them.
Would your client, Ms. Trufano, be agreeable to having Shea O'Brien apply for a separate SUP in order to clarify that?
I couldn't recommend that right now for the reasons I gave you. I couldn't recommend that to her. Whether she would be agreeable, I'm not answering. For two reasons. One is the parking study is still up in the air, and I want to see what happens with that. I don't want to go before the board and start making representations about the parking study until I know what the parking requirements are going to be, hopefully in a few months from now. They'll settle that issue. Once that issue is settled, we can certainly come back before the board, because it's not about those conditions that
Okay.
the amplified music and those kinds of things. It's really about the parking issue.
Michael,
Sir?
will you speak to that matter? Is it going to be difficult to clarify the parking requirement for 127? Are the issues such that it is not simple?
Well, so I wasn't on the planning board for any of those prior discussions about those, although I was often there as the representative from the village board, the liaison. Correct me if I'm wrong, Jane, but some of the complications are that in the past there were various relationships between two different addresses, 123 and 127, and parking, and I don't remember which was which, but parking at one address was being drawn upon by parking requirements at the other address.
Yes.
So if that still stands as part of the overall approval, that would certainly complicate matters. I do know in the past that planning boards have requested that contracts be drawn up with off-site parking lots for specific parking arrangements after hours. I don't know if any of those, I don't recall that any of those were actually done, or if they are, whether they're still in effect. So I recognize Ms. Daly's and her, I recognize her reluctance, and I wouldn't disagree with it if I was in her position. I think those are issues. In addition, the planning board has, and again, I'm speaking, I'm not representing the planning board, but I know that the planning board and the village board and the planner are all at some stage of trying to address the parking requirements in the code, and I don't know where they stand at the moment. I know the planning board has made comments on the record to the planner, and I would say the sooner we can get those, speaking only for myself, the sooner we can get those done, the better. I think it would alleviate a lot of issues, and that might facilitate this particular SUP coming forth sooner. But I also say, since you asked, that I think it's also wise that the business owner have a chance to develop a reputation here, because I think that would also be helpful.
I have a concern regarding the lack of a properly constructed and landscaped and fenced berm that was required. It should have been done before anything went forward, and it never was. And there was I guess a certificate to occupy Rascals in the absence of that. And if we're talking about parking, and we know that the neighbors are significantly inconvenienced by some of the past operations, I'd really recommend that berm be brought back into the discussion.
Carl, may I address something?
Sure. Richard?
I was just going to suggest that, just to piggyback on what I said before, is that clearly there are a number of issues, and this property has a long application, and all of it doesn't. So that rather than burden the new business owner with all of these issues in a public forum, perhaps it would be useful to have some sort of facilitated conversation before they make a commitment with some representation and the planner and some neighbors, and the business owner, and if necessary the property owner, to lay out what all of these issues are, and so that they have time to understand, and they also have time to talk face to face to neighbors outside of public meetings, to perhaps develop a rapport so that it can be determined what things need to be addressed and what they can reasonably expect to do.
Thank you. Do you think your client would be willing to be a partner to that kind of meeting?
I can't speak to that, but I can tell you that I think it's, even that level of a conversation is premature until we know what the parking situation is going to be, where the parking comes down in a couple And part of going before the planning board and reopening this special use permit opens all that conversation. And I think that when we're at that point, those are all viable questions. I don't know that we're there yet, because as I said, they wanted to develop their reputation. They want to have support, like before the planning board, when other people have gone in, and they've had a half a dozen people show up and support them and say they're a good business, I want them in my community. That's the kind of reputation that Shea O'Brien's hopes to build, so that when they go before the planning board, they do have the support of the neighbors. And hopefully you'll be there on their side then. But I do again just want to say that I'm concerned about your tabling the appeal until the village board determination or the village board's lawsuit is finalized, because it could be a year and a half or so. Now, I don't know if it's appropriate, but I've prepared written documents, which I'd be happy to submit tonight to you, which set out a whole bunch of legal arguments, as I'm known to do. I was going to summarize them, but I will save that for a time when you decide to continue this hearing. But I just again want to say that I think it's very challenging for Shea O'Brien's to be put on hold for an extended period of time with this issue of the special use permit hanging out there until whenever.
So I guess I'm not clear. Let's say it does take, I know it's going to take a while for this lawsuit to right itself. And Shea O'Brien's is doing a very nice business. They're great neighbors. So what's to be lost by them continuing building their good reputation while the lawsuit does its thing? What is to be, they're continuing with their business. It's not like the SUP is telling them that they have to close. They're continuing, right?
No, but they're still at risk.
How so?
They're still at risk that
because of parking?
No, they're still at risk because you've got an appeal against a building determination that...
But if we say that until the lawsuit is settled, then we may rescind our appeal, but if it takes a year, well, then they're in their business for a year. We are asking for a resolution to the lawsuit.
Except that let's assume that the court decides in favor of the village board.
This is in a year.
Whatever they decide. 3 weeks in a year. I give them predicting the court.
Well, you were just saying that it's going to take a long time.
I said it could take a long time.
And it will take a long time.
Or they could come back and want to settle it.
Who?
The village. Through their attorneys. They could want to settle the matter. I mean, these things can go on for a very long time if they work their way through a court system. They also have a way of settling themselves. However, they're two completely separate and distinct cases. One is for the village board, which you don't have jurisdiction to review their determinations, which is why I went to court. And the other is the building inspector's determination, which you have the authority to review. And so I don't understand why it's proceeding if they're two separate and apart cases.
All right, wait a minute, I've got a question here now. I want to ask a question. Are we being asked to uphold or deny the building inspector's determination?
No.
What? I don't really understand this.
We have applicants who are questioning the building inspector's determination.
Yeah, but is this our jurisdiction to either...
We are the Board of Appeals. No other body in the village has that responsibility or power.
Okay, all right.
Mr. Chairman, I think that it is probably best addressed by our special counsel, because I too, in other words, even by process of elimination, that doesn't necessarily mean that all appeals are equally valid before the Zoning Board of Appeals, just because there's no other more apparent board. So I
didn't intend to say that.
Okay, I'm sorry. I just without counsel here, I'm also unsure as to what determination I don't believe that it was, and when it was first submitted to me, I didn't think that it was an appeal of a determination. It wasn't a decision. It was addressed, it was a memorandum addressed to this board at this board's request, as opposed to a property owner, an order, a determination, in order to remedy or anything of that sort, or denial. So I didn't see it as, I see the determination as the one that was made on June 18th. And now that that's in litigation, I'm uncomfortable really perpetuating a conversation that is largely legalistic when our special counsel isn't here to speak on our behalf.
Thank you.
I just wanted to add that the timing is important to me in the fact that I have a lease at that building.
Would you stand up, please?
Yeah, I have a lease at that, I'm the only one that stands up. I have a lease at that building. I have an option to buy the building. Frankly, I don't know if I want to buy the building or not because of all of this that's going on. How can I go ahead, if I go ahead and purchase the building in 6 months, and then the special use and all this gets turned down, then what am I gonna try and sell shoes out of that store? You know, like what am I supposed to do? So it's important to me that this gets settled, because I have a lease at the building with an option to buy the building. And from a business point of view, you wanna buy the building as soon as possible, but this is a huge headache that this is turning into. And I wouldn't wanna buy the building if this perpetuates, you know, like, so I mean, so the timing is of the essence to me, like I would like to know sooner rather than later. And if the special use permit is in effect, and everything, you know, my attorney will move forward and exercise our option to buy the building, and the people on Prospect and Orchard may well be finished with the Toscanis for a while, for the foreseeable future. I don't know, you know, that's just my point of view, you know, like, I signed in good faith that there was gonna be a special use permit there. The special use permit is there, and now there's all these problems and whatnot, and from my point of view, why would I wanna purchase the building? If the special use permit is in effect and everything is good to go, then I wanna buy it, but I wanna be here for a long time to come. Thank you.
Carl?
Yes, Evan.
May I ask a question, a point of clarification?
Yeah.
I'm a little bit confused about the special use, you said something about the special use permit.
Yes.
Forget all the history, forget everything.
All right.
Okay, so is a restaurant with an auxiliary bar, does a restaurant with an auxiliary bar need a special use permit to operate where Shea O'Brien's is physically operating?
Can't answer that question.
Yes, I believe a special permit is required
Okay.
for either of those two uses.
Okay, so then what if I may, just to finish my
Sure.
thought, what I would like to say is, with all due respect, and I certainly feel for the position that you're in, I hate limbo for even 20 minutes, so I'm very sympathetic. On the other hand, this has been an ongoing problem in our community, and I'm assuming that when you entered into this agreement in the first place, you had your own legal counsel who could explain to you what the parameters were. So it seems to me, to impose that, no matter how golden you are, and I am gonna come to your restaurant, but no matter how golden you are, to impose that on the neighbors who have been dealing with this for so long doesn't seem to me to be reasonable. You know,
The only thing I was saying was that it was put forth as to why it matters with the time.
I'm sorry,
answered-
okay.
I was put
Okay.
forth, somebody asked me what the business is.
Okay.
I put forth that it matters to me, the time matters to me, because as anyone knows, when the ink dries and the lease, tick-tock, time is against you.
Right.
I have the option, I have a window there to buy a building and a property.
Right.
I would love to do so, but if this is all wrapped up one way or the other, I don't know which way I need to go. That's all I wanted to say.
Dr. Nash?
You know, our objection was, as Christine said, was not with the current business. But the SUP goes with the building, and the
Goes with the property.
with the property, and the SUP, we believe, has clearly expired. And it seems to me that Michael's suggestion about applying for a new one would allow Mr. Murtaugh to to operate his business in a timely manner. Ms. Daly's objection is something about the parking. I mean, in the SUP, they had parking allotted at 123 that was in the SUP. I don't know what other issues are coming up about parking. I haven't been informed about that. But that's something that could be worked out with the planning board. So it seems the best solution is the one that Michael brought up.
I would have to point out that it has not been determined that the SUP has expired.
I understand it hasn't been determined, but if the timely solution would be to apply for a new one. To apply for a new one, that would be the timely solution. As Ms. Daly said, it could take a year for this to be worked out. This is not this is a hardship that was not created by us. We didn't sue the village.
Mm-hmm.
So it seems it would be worth it for the owner to say, yes, let Mr. Murtaugh apply for a new SUP. Then he could operate his business.
I think you really need to talk with Ms. Trufano, Mr. Barnett, concerning her willingness to have you apply for your own special use permit.
Okay.
Well, if he buys the property and she doesn't own it anymore, can't he apply for a new SUP?
Yes.
Wouldn't the old SUP be mine then?
It would be.
Yes.
I don't know. I just talked
Yes.
out loud.
Goes with the property, not the
Yeah.
person.
Richard?
What's clear, I think we get a little muddy here. The planning board does not make decisions on parking. We have no discretion on parking,
Okay.
not currently. And I think even if I poll our board, we find we have different opinions. I'm way on the other end. I don't think we have any restrictions on parking. But we have no ability to negotiate a parking deal. He either fits it or he doesn't.
But you do
If
have.
it doesn't fit, you've got the ability to make decisions and changes, not us.
But you have authority to review a site plan and to determine how many parking spaces.
But that's a second grade calculation. Square footage on the business, square footage on the lot. I can tell you exactly how many parking places he needs. And it gets much more exotic when it comes to this property.
And then if there's not enough, then they have to go for a variance.
They have to go for a variance. We have no discretion. We can't turn around and say, well, they're closed, but good enough. Or, you know, based on the business, it'll work. Or based on the neighborhood, it'll work. I mean, he's lucky, he's got a side street that he's hardly used, so he's got plenty of side street parking. But I know, I used to live there. But we don't have that discretion as a planning board. As a planning board, we have to go along with the calculations as they are presently in the zone.
Okay, thank you.
I'm just confused because they did those calculations, they came up with a number of spaces, and that's what they presently have. They presently have the number of spaces that they were required to have, so I'm not really sure what this parking issue is.
I think you gotta look back and see that, and I wasn't on the board either at the time, but I think if you go back and take a look, I think you look at that planning board was a little more creative. That planning board was somewhat creative with the law. The law says we take a look at the size of the lot, the amount of square footage in the building, and that gives us the calculation. That planning board was a little bit more creative with that approval.
Ms. Daly.
What I was trying to say is that it's not quite as simple as it might sound to go before the planning board and reopen the special use permit. But I think what is before you right now is the question of, did the special use permit expire? And I want to go back to something Kurt said. The September 11th letter, from what I understand from the appeal that was filed by Ms. Nash and, Dr. Nash and Ms. Marmo, was that they were appealing Kathy's determination in her letter of September 11th that she believed that the permit had never expired.
Yes.
That was what they were appealing, and the ZBA has the authority to hear appeals from the building inspector's determination. She was very clear in that letter that the June 15th letter, which was, you can tell from the minutes of the village board meeting, it says, direct the building inspector to determine that the special use permit had expired. The letter was drafted by the village attorney. It was merely sent out on Kathy's signature. She has said that that didn't reflect her opinion, that she never felt it expired. The issue is not, was it appealable for, because it's still the June 18th. That's, the inspector has said it wasn't there. The lapse goes back to when she issued this certificate of occupancy in January. Now, if there was a lapse in this, it occurred before she reopened on January 18th. I think maybe we can agree on that. The law says that you have 60 days. The village law, New York State village law says 60 days from the date of the lapse. That would have brought us till March 19th. So I don't agree that it was a June determination. That's the one the village board made. That's the one that's in the Supreme Court.
Excuse me, on a point of order. The appeal was brought by Ms. Daly to the Zoning Board of Appeals. She withdrew the appeal before this body.
Yes.
And now she is arguing her case that she dropped already before you. And I don't think that's appropriate or proper, especially since she had then sought litigation against the village board and against the village board personally. And I think, without legal counsel here to advise you, this is inappropriate.
Yes, okay. I think at this point we will entertain a motion to adjourn, leaving the matter where we voted earlier, that we will await the outcome of the lawsuit before you press your issue.
I move.
Second.
I so move.
You move it
Your
and
words.
second
I
it?
second it.
All in favor?
Aye.
All right. Motion to adjourn.
So moved.
Second.
Oh, just for a workshop?